Joshua Tellez,
Yes, Your Honor.
but y'all are on this side.
Yes.
And where's your client? Come forward.
Cutter and Associates.
So are you in law school or going to, where are you attending law school?
St. Mary's.
Oh, wow. What year?
I'm a 2L now.
2L? Oh, well, you're practically done.
Yeah, almost.
Well, please, whenever you want to come down, you're more than welcome to come down to the court.
Thank you.
You're welcome. All right. Who is the prosecutor on, how do you pronounce your last name?
It's Tellez. It's like it's pronounced T-H-E.
Tellez. All right. So if y'all will move towards this way, because counsel, you're on this side and your client is in the center.
How you
The
doing
double
today,
L's,
boy?
I'm doing great. The double L's always get me.
Yeah, the E has that little apostrophe on top of it, so. Yeah.
Well, we're gonna blame it on that because in the documents, they don't have apostrophe over the E.
Yeah.
So Tellez. Do you all have the motion?
We have the motion as well as the agreed order, Your Honor.
All right, so if you could give me the motion. Okay, thank you. All right, court is calling 2020 CR 2266B, State of Texas versus Joshua Tellez. Could I have parties announced for the record for the state?
Jason Garrett,
Defense?
Your Honor, Anthony Bancroft standing in for Miss Lee Cutter,
All right, and then you have with you also.
and I have my.
You want to announce?
Miguel Esparza.
All right, thank you. And are you Mr. Tellez?
I am.
All right, Mr. Tellez, you have an attorney who's standing in for Attorney Cutter. Do you have any objection to your to this attorney standing in for Ms. Cutter for this hearing?
No, ma'am.
All right, so we're here to set a bond. He's on deferred adjudication, so he's entitled to a bond. It's my understanding that the state and defense have reached an agreement of $10,000. Is that correct?
That is correct, Your Honor.
That's correct, Your Honor.
All right. For the record, the court is aware of the defendant's history because he is on deferred adjudication out of this court. And the court has done the appropriate research that's needed in order to set a bond. The court will find that the bond in the amount of $10,000 that has been agreed upon by the state and the defense is an appropriate bond. Now let's talk about conditions. Based upon your history, the court is going to order that you do weekly UAs with probation until your case is heard. Do you understand?
Yes, ma'am.
And we're going to set this. Normally, we need a hearing, just set it for a contested hearing. I don't know if it's going to be contested or not, but we'll put it on a contested date.
Yes, ma'am.
And we're off the record.
Thank you, Your Honor.
All right. And I'm sorry, state you're excused.
Your Honor, may I be excused?
Not yet.
July 11th.
All right. We're coming back on July 11th at 9 a.m. And that will be your hearing. I am telling you this. I always keep an open mind on everything. But between now and then, if there's some issues in the motion to revoke that need to be addressed with you doing certain things, it would probably be in your best interest to do those things. And when I put on here that you're to do weekly UAs from now until then, you had better do weekly UAs from now until then. You understand?
Is there a designated day or do I just go
Oh,
on that?
probation is going to let you know. So they're going to keep you out here till you talk to probation. And Ms. Ferguson, if you can give them a reset
Yes,
form.
I'm doing, I just need the file, Judge.
All right. Here you are. All right, that will be it.
All right, then, Ms. Boyd, you have a good day.
All right, thank you. You
Your
too.
Honor, thank you for your time and your patience.
You're welcome. Have a good one. Hey, and good luck.
Thank you.
It's going to go quickly.
Yeah.
Enjoy it while you can, because afterwards, once you start signing your names to things and it's only your name and you're not practicing under somebody, that's when your
Yeah.
heart beats.
Thank you.
You're welcome. Have a good one. All right, court is, oh, and who is this behind you?
This is one of my law clerks, Miguel. Is that okay if he stands up here with us?
Oh, sure.
He said
Miguel, what's your name?
Miguel Esparza.
All right, so what are you doing? Are you in school, law school?
St. Mary's.
Oh, what year?
Second year now.
Oh, well, your law school days are almost over.
Yeah, almost.
After that, it's very quick. So do you want to practice criminal law?
Yeah.
Oh, hey, well,
I get
you're
the
always,
opportunity to come and watch and
well, you're always welcome to come to the 187th anytime. And don't be shy. Talk to the attorneys. You will find that on the criminal side, no shade to civil attorneys, but on the criminal side, They're always willing to help you. All right, court is calling 2020 CR 2266B, State of Texas versus Joshua Michael Tellez. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense,
Lee Cutter for Mr. Tellez, Your Honor.
and what's your name?
Miguel Esparza, Your Honor.
All right, and just for the record, Miguel Esparza is a law student at St. Mary's. So this is, I believe this may be his first time on the record. Is that correct?
That's
Second
correct.
time actually.
Second time on the record. Okay.
He was here with me the last time.
Yeah.
Ah, yes, okay. All right, Mr. Tellez, you're Mr. Tellez?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Joshua Michael Tellez who was placed on deferred adjudication in 2020 CR 2266B for the offense of possession of a controlled substance penalty group 1, less than 1 gram on November 9th, 2020 for a term of 2 years? Is that you?
Yes, ma'am.
State.
Yes, Your Honor. Violated condition number 41 in Bear County, Texas, the defendant Joshua Michael Tellez, the detonator failed to attend and provide verification of attending 90 Narcotics Anonymous meetings in 90 days from September 27th, 2021 through August 31st, 2022, in violation condition number 41.
How do you plead to that? True or not true?
Your Honor, I didn't hear what you were asking me before. It has complete, oh, sorry.
I did complete the 90 days and 90 meetings.
So is your answer true or not true?
Oh, I get not true.
Okay.
Violated condition number 2, on or about the first day of October 2021 in Bear County, Texas. The defendant Joshua Michael Tellez, the detonator consumed alcoholic beverages in violation condition number 2.
How do you plead to that? True or not true?
On a waiver of remaining violated condition.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
We have just one something on.
Sure.
I'm sorry, that's an alarm.
Okay, is it an alarm like don't plead true?
I was like, I don't know if. Okay, then sure. ma'am.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Did you understand? If you have an agreement, you think with the state, court does not have to follow that agreement. This is the contract with the court, not with your attorneys in the state. Did you understand?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 2, to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor.
Yes.
It is to deny the motion and extend the individual honors for 3 years with weekly weekly reporting for 90 days and also random UAs for 90 days, Your Honor.
Is that what you're requesting?
Yes, Your Honor.
All right, state you're excused.
Thank you, Judge.
All right, so why should I do this?
Your Honor, this is a very old case and he's completed his 90 narcotics in 90 days. He's completed outpatient treatment. You did have him on 6 drug tests a month at random with a daily call-in for quite a bit of time, and he only missed 3 call-ins that whole time. Yes, he missed 3, but that's it. He did obtain his high school diploma. He works for a government contractor. He also works for Spectrum. He's really done well with all of the treatments he's received. He'll drug test today, but we are asking this court to please allow him to show you for the next few months that he's very serious, and he's also spent 20 days in jail.
Okay.
as a result.
All right, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth? So help you God.
Yes.
All right, you can lower your hand, state your name for the record.
Joshua Days.
All right, what's your position at Spectrum?
I'm an inbound call center agent.
All right, are you the person when you call and you're on hold for a long time?
No, I'm the person who I handle all the people who were on hold.
Oh, okay.
So I get the back end of it. People are angry at me a lot, but I'm doing good at bringing them
All
down.
right, so why have you not been doing well on probation? What is your issue? Do you want to go to the state jail facility for 2 years?
No, man.
All right, so
I've changed a lot over the course of since I've been on probation, since the motion to revoke has begun. And I've completely changed. And I remember I was here last time when it was Thursday, and you were saying like, why do people change after the fact and stuff like that? And I hear you, but I've made a considerable change as far as my personality and things that I do, my habits, etc. I'm just a completely different person now, and I realized that I was becoming a product of a system due to my old decisions. And considering that I'm a new person now, I don't want to be a product of that
All
anymore.
right, and how did you enjoy the Bear County Jail?
I hated it.
All right, so I do see probation. I'm reading the court summary. So he's telling me he's completed his GED,
Or a high school diploma.
high school diploma, so that's been completed. And he's informed me that he did do his 90 sober meetings in 90 days.
Yes.
So what are you planning on doing with the rest of your life?
Well, nothing short of being very, very rich, honestly. Like, I don't mean to say it like that, but I have big dreams. I have very high ambitions, and I have the resources and the drive to accomplish 100%.
Well, I always tell people being very, very rich. Oh, yeah. My thing is
what I can
people
do
should,
with it.
yeah, but
Yeah.
you know, it's people should want to be able to support themselves. I'm always shocked when people don't say, hey, you know what? I just want to be happy.
But yeah, I have big plans for like things that I want to do and stuff like that. I'm also working on in the process of like starting a nonprofit for foster kids and stuff like that, because I was a foster kid as well myself. And so I have a lot of, I could go on and on about my dreams, honestly. I have big dreams. So
No, you know, there was always a big issue with the foster care system,
I agree.
where children would age out of the system, and then it's good luck to you.
Mhm.
And there's a program that I used to be involved in. I used to be on their board. It's called Youth Transitioning into Adulthood.
Mm.
And so it was designed to help foster children. Because at the end of the day, I think all of us who went to college, when we went to college and you're short on money, you would pick up the phone, call your mom or somebody to send you money. But when you think about it,
Who's to
if
call?
you're a foster child, who are you going to call? So I'm glad you're looking into doing that to make the system better for foster children. I really wish they would take advantage of the fact that they can go to college for free.
Yeah. I didn't.
And
take
you didn't take
of it,
advantage.
no.
Look at this.
I know.
You had an opportunity
But I'm
to have
actually
college
I'm
for
actually
free.
glad that I didn't. I needed to go through everything that I had to go through at the time that I
Mhm.
did, including this.
Mhm.
And this was the motion to revoke was actually one of the best things that ever happened to me, honestly. It made, like I said, it made me realize that I was becoming a product of my decisions from years ago, and I really was not that same person at all. So then I completely changed my behaviors. I read every day now, like self-development books. Like I'm very intelligent, like self-taught. Everything that I've built as far as the business and stuff like that, it's completely self-taught. So I get myself.
Well,
pat on the back.
if you're looking for join a nonprofit, one of the things you should see if maybe you can go to the legislature and change the law, because sometimes when you're immediately out of foster care, they did extend the time for you to apply and go to college. And all you have to do is take one course, and you
Wow.
take that one course and then it's available for you. But maybe you want to talk to the legislature about changing that, because sometimes when people are in foster care and they age out, they don't have necessarily the guidance to say, hey, just try college. And then if you don't like it, then you can do something else, but at least register for a class so it's available to you.
My goal with that is to cultivate a bunch of business owners who can, we can kind of like start like a little school to where we go to people who are gonna age out, and then we teach them new ways to like make money so that they have something to do when they get out.
Well, you should actually talk to the organization YTIA, Youth Transition into Adulthood, and let them know that you were in foster care, and let them know different issues you see, because they're always open to that. All right, this is what the court is going to do. Court is finding violation of condition number 2 true. If you're drug tested today, what are the results going to be?
Negative.
All right. So, Ms. Abrams, we're going to do a drug test today by 3 p.m. If it's negative, extend for 1 year. If it's positive, extend for 3 years. And there are to be regular random UAs if he's negative. If he's positive, as I said, extend for 3 years and have him come back here to look me in my face and tell me why he was positive.
But this case expired in November of 2022.
Mhm.
So if we extend them for just that 1 year, that case would have been terminated 2023.
Yes.
So if negative, regular random UA thereafter would not be.
No, if he's, because it seems to me, and if this is not the party's intent, and if people don't, we can go off the record, if this is not the party's intent, let me know. It seems to me that when this motion to revoke was filed, I asked him to do certain things. He has done it. He's on probation. We're trying to rehabilitate people on probation. It seems to me that he's addressed the issues I wanted addressed. He's obtained his diploma. His phone won't stop going off. Maybe I should extend him 3 years for that. And, you know, if he's negative, then
I just want to make
yeah,
sure.
no, I appreciate it. So, Ms. Abrams, how do you feel about the court? If he's negative, he'll be done. If you're positive, you're not going to be done.
I hear you. I will definitely be negative. I haven't been using and I don't use.
All right, so you need to be drug tested. And Ms. Abrams, if you let them know he needs to be drug tested for alcohol as well, and that's by 3 p.m.
Sounds good.
Yes, ma'am.
All right, is there anything else?
No, Your Honor, thank you.
All right, good luck to you.
Thank you. Have a good day.
Thank you, Your Honor.
You're welcome. Good seeing you. Jessica Bonner. Do you have a file stamp, please?
I'll take care of it.
Oh, no problem. Thank you. All right, could I have someone for the state? It's Criminal Trial Division. Court is calling 2024 CR 4983, State of Texas versus Jessica Marie Bonner. Can I have parties announced for the record for the state? Defense,
Sean Sheffield.
are you Ms. Bonner?
Yes, ma'am.
Did you understand you're charged with the offense of fraudulent use of possession of identifying information, less than 5 items, elderly person? That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, there's a $2,500 fine. State is recommending deferred adjudication. There's to be restitution to Caroline Caldwell. Did you understand that to be the plea?
Yes, ma'am.
Outside the agreement, state is requesting that your deferred adjudication be for a term of 8 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with Caroline Mullins Caldwell. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contact.
Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client?
Your Honor, we just asked court to follow these recommendations.
All right, what's the name of the complainant's son who allowed you in the home?
It's David Caldwell.
What's your relationship to him?
He was a friend.
All right, do you have any children?
Yes, I do.
What are their ages?
18 years old, 17 years old, 16 and 15-year-old.
And who are they with?
They're with their dad right now.
What's your drug of choice?
I was on meth, but been clean.
All right, were you clean when you committed this offense?
No, ma'am.
All right, so why are you taking things that don't belong to you?
I was in the wrong place. I needed money at the time with my kids, and it was just opportunity, and it was wrong for me to do it.
Who is Melissa Campos?
That I have no idea.
And Is Child Protective Services involved in your case?
I don't think so. I'm not sure.
When's the last time you had employment?
Well, I was working as a cleaning houses, and then I lost that.
Mhm. All right. Anything else?
No.
This is what the court is going to do. Court is going to sentence you to a $2,500 fine. That will be probated.
Thank you.
8 years deferred adjudication. There's to be no contact with the following persons: Caroline Caldwell, David Caldwell. There's to be no unsupervised contact with minors. There's to be a referral to felony drug court. That'll be first. A TAP evaluation in custody. And then last, if none of those places accept her, then we can do a referral to Esperanza Court. And follow TAP recommendations if she's not accepted in one of those treatment programs. There's to be the UA hotline. Regular reporting by Zoom or in person. Field visits 1 time per month for 4 months. Then at probation's discretion. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors or in housing. You can't be cleaning houses or any place where you're around money or checks. You understand? 200 hours of community service restitution. I'm going to order parenting classes. Once you complete parenting classes, the community service hours will be deemed satisfied, and there's to be restitution, if any, to Caroline Caldwell. All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know. If you feel as your probation officer is not addressing that, you can come to court. We're here, but not on weekends or holidays. If you feel like you're going to use, pick up the phone, call your probation officer. And again, if they can't get you any help, come back to court. You understand?
Yes, ma'am.
All right, thank you.
Thanks, Jeff.
All right, court is calling 2023 CR 2172, State of Texas versus Satara Portillo. Could I have the parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
The attorney of record is Joanne De Hoyos. Joseph Statesman standing in. Ms. Portillo, will you give this court permission for me to do this in place of Ms. De Hoyos?
Yes.
All right. Ms. Portillo, did you review the document entitled Motion to Enter Adjudication of Guilt with your attorney? Did you understand it?
Yes.
Are you the same Satara B. Portillo who was placed on deferred adjudication in 2023 CR 2172 for the offense of possession with intent to deliver a controlled substance penalty group 1, 4 grams to 200 grams on July 27, 2023 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
Violating condition number 35 on or about the 25th day of March 2024 in Bexar County, Texas. The defendant, Satara Portillo, who then and there failed to follow the TAP recommendations to include inpatient as directed by the court in violation of condition number 35.
How do you plead to that? True or not true?
True.
Your Honor, state waives all the violations.
Any objections to the state's waivers?
None.
Did you understand by pleading true to violation of condition 35, the court could find it true, grant the motion, find you guilty, sentence you up to life in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 35?
Yes.
Court will find violation of condition number 35 true. Is there a proposed agreement?
Yes, Your Honor, it's alter demand for state ISF, the substance abuse program, followed by aftercare with ISP, weekly UAs with zero tolerance.
All right, so what I can tell you all, if you want to reconsider things, you can, but I'm not following that agreement. Back on the record in 2023 CR 2172, State of Texas versus Satara Portillo. Can I have parties announced for the record?
Daniel Escobar for the state.
Joseph Stateson, continuing to fill in for Mr. Hoyos.
All right. The defendant had entered a plea of true to violation of condition number 35. Do you wish to continue with your plea of true in violation of condition number 35?
Yes.
All right, the court will find violation of condition number 35 true. Is there a proposed agreement?
Your Honor, if I may,
Yes.
I discussed this with the COO, Ms. Abrams, and ADA Daniel. My client is asking to be continued. We had a recommendation that was a three-way agreement. I understand the court didn't want to follow that. I had proposed something to Daniel. I'm hoping that you would consider this. But just some background a little bit first. Her prior MTR was disposed of February 27th, 2024. But she was booked February 3rd, 2024. So from February 3rd till today, according to the clerk, it's 137 days. So she's had the equivalent of a, not court ordered, but equivalent of a 4-month jail sanction. She will admit, well, she did admit that she refused to sign conditions for inpatient. She's willing to do not just ISF, she's willing to do SAT-F. She's willing to redo all her classes. She's been in jail for quite a long time. That's her own mistake. She admits that she didn't want to sign it. Maybe she was reluctant to, but she thought that she was supposed to get out, have court, and come back and do things. And she never left the jail. And out of frustration, she didn't sign the conditions.
No, I don't think she's a good candidate for probation. She was supposed to sign the conditions. The TAP recommended inpatient treatment, and she didn't do it. So I don't think she should be continuing on probation. She was given opportunity, and counsel, as you just stated, this is not her first motion to revoke. Her previous motion to revoke was on February 27th, as you stated, and there was a violation of condition number 1. And I ordered that there be a TAP evaluation in custody to follow those recommendations. And she decided that she didn't want to follow those recommendations. I don't see how there's anything that I can do anything for her. People don't get it. You're not supposed to, when the court orders you to do something, for example, to help you by following the recommendations of TAP. TAP recommended inpatient treatment. And I know sometimes people get to talking to people at the Bexar County Jail. And when I say people at the Bexar County Jail, I mean other inmates. And they give people advice, and people want to follow the advice of an inmate, not realizing that, guess what? That person is in custody. But I made an order, and we can't do this thing where I order somebody to follow the TAP recommendations, and the TAP says inpatient, and then somebody says, I'm not signing to go to inpatient. And then what ends up happening when reality hits that your range of punishment is 5 to 99 years or life, then people come before the court and they want to say, oh, you know what? I changed my mind. Now I will do inpatient treatment. So that's where we are.
And
I don't
Your
think
Honor,
she's a good candidate.
she's also willing to take a felony conviction, change it from deferred to straight probation. She's willing to do the harsher inpatient treatment program with 0 tolerance. It was a poor decision for her to not sign that. 4 months she's been in here. She's willing to sign this, willing to do this, and even add to these conditions.
I just don't think she's a good candidate. If somebody wants to argue to me why she would be a good candidate for probation, when this is her second motion to revoke, and I ordered her to follow the recommendations of the TAP evaluation, and she didn't want to follow them. But now she does because, I don't know, I guess she thought a motion to revoke would not be filed against her.
Yeah, I didn't know that that's what would result.
Oh,
I
so
thought.
these are called consequences.
Well, Your Honor, also the charge itself, people who are affected with these substances may not make the best decisions in life. To prevent her from reoffending in the future, relapsing, and she's willing to do even more intensive inpatients.
But she's charged with possession with intent to deliver, and I understand that sometimes when people have possession with intent to deliver cases, Sometimes they're selling because they're also using. But the amount of methamphetamine she had was 27.980 grams. I don't think probation is appropriate for her. I'm not going to continue on probation. I'm going to revoke her and find her guilty. Does anybody wish to speak to punish her?
Defense would ask for the minimum time, Your Honor. With credit for time served.
All right, I'll sentence her to 5 years in the prison. Give her credit for any time served. And I'll ask for the therapeutic community. All right, good luck to you. Thank you. Court is calling 2024 CR 3778, State of Texas versus Vince Ventura Ibarra. Can I have parties announced for the record for the state?
Daniel S. Clark for the state of Texas.
Defense,
Orlando Castañon.
are you Mr. Ibarra? Did you understand in count 2 your charge of possession of a controlled substance penalty group 1 gram to 4 grams? That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, court does not have to follow your plea. Did you review the plea bargain page with your attorney? Did you understand it?
Sure did, yes, ma'am.
According to the plea, state is proceeding on count 2. Punishment is to be assessed at 4 years in the prison, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Judge.
Then to count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything that you wish to say on behalf of your client?
Just judge that, believe this is a fair agreement. He understands he has an addiction and that he is looking to address that. He does have a parole case that we asked that this be run concurrent with. That cause number is 2022 CR 2107. He's currently out on parole and awaiting a revocation hearing on that.
All right. The court is going to find you guilty. Court will sentence you to 4 years in the prison. Give you credit for any time served. There's to be no contact with Margaret Marie Gomez. This is run concurrent with 2022 CR 2107. I'll request the therapeutic community. The therapeutic community does not increase the length of time you're in custody. It's just a program that potentially could help you if you're accepted into it to kick your drug addiction. You understand? All right, we can go off the record. How old are you?
35 years old.
All right, so you're getting close to where you're going to have more of your life behind you, in front of you. You're going to have to make some decisions on what you want to do with the rest of your life. If what you want to do with the rest of your life is spend the rest of your life incarcerated, Texas will definitely provide a prison for you. You understand? All right, good luck to you.
Thank you, Judge.
You're welcome. All right, court is calling 2019 CR 11017W, State of Texas versus Michael Paul Shoemaker. Can I have parties announced for the record for the state?
Daniel S. Clark for the state of Texas.
Defense?
Sean Henderson for the defense.
And are you Mr. Shoemaker?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and cause number 2019 CR 11017W with your attorney, and did you understand it?
Yes, ma'am.
And are you the same Michael Paul Shoemaker who was placed on deferred adjudication in 2019 CR 11017W for the offense of possession of a controlled substance penalty group 1, less than a gram, in a drug-free zone? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 7 on or about the 23rd day of May 2024 at the Port of Galveston, Texas. The defendant, Michael Paul Shoemaker, part of Bexar County without the written permission of the court and or the supervision officer in violation of condition number 7.
How do you plead to that? True or not true?
True.
Your Honor, state waives all the violations.
Any objections to the waivers?
No objection, Judge.
Did you understand by pleading true to violation of condition number 7, the court could find it true, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 7?
Yes, ma'am.
Court will find violation of condition number 7 true. Is there a proposed agreement?
Yes, Your Honor, it's to alter and amend for MRT within 10 days and GPS for 90 days.
All right. Defense, is that the proposed agreement?
It is, Your Honor, and I do want to let the court know, my client lives in St. Hedwig here in Bear County. He works as a heavy equipment operator in Bernie and Kendall County.
All right, so why is he leaving Bear County without permission?
Judge, he was actually going on a cruise, and that was the reason he left Bear County.
Was that cruise approved by the court?
It was not, Judge.
So is there anything you wish to say?
No, Your Honor.
It would probably be in your best interest, but okay. All right. And so this number 1 that's in the motion, I'm not going to consider it as true, but what is happening to the new number 1?
Judge, my understanding is that that was out of Galveston. That's ours. I didn't see
Okay.
anything pop up.
And that is correct, Your Honor. The new case is out of Galveston County.
So what is happening with that case?
It's currently pending, Judge. I don't represent him on that, and so I don't know what ultimately is going to happen with that case, Your Honor.
I'm not going to take that in consideration and not consider it. I'm sorry, I'm not going to consider it or take it in consideration since the state waived it, but allegedly.
Or yes, what the new number 1 is, Judge?
Yes, who is
or-
the violation of a protective order with? Did he go on a cruise with the person he's not supposed to be with, allegedly?
Allegedly, yes, Your Honor.
So where do we, off the record, where does it come in that he violated a protective order? How did that happen? That people go on a cruise and things didn't end well?
I'm sorry, Your Honor.
Did he go on the cruise? Because you're saying allegedly he went on a cruise that he had a protective order against. He went with that person on a cruise.
He did, Your Honor. And so when he got on the cruise, since the cruise was leaving the country, Judge, I believe they go through and check everybody's passports. And it was during that process that they found there was a violation or that there was a protective order in place with the person that he was going on the cruise with.
Oh, and he didn't get to go on the cruise? They
He
stopped
did
him?
not. He did not. It was right after boarding, Judge, that that he was removed from the cruise.
Did he pay for the cruise of the person who he has a protective order against?
Yes, Judge.
He paid for it, or the person who he has a protective order against paid for it?
Both.
Both of y'all paid for it. Did they give you a refund?
No, ma'am.
Okay, this is just questions that I have. I'm always curious about things. All right. We can go back on the record. You want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Michael Paul Shoemaker.
All right, why do you have the tape around your wrist? What's going on?
So and when you get booked in the main jail, it's every stage you go through. And
Ah,
I just didn't take it off. They took me straight over this morning, so.
okay. All right, this is probation's recommendation and the state's recommendation. What I'm going to do is deny the motion. Is this his first motion to revoke?
I believe it's the second, Judge.
I'm going to deny the motion, alternate amend conditions to ISF cognitive. And with regards to his transfer, does he need his probation transferred?
No, he's living here in Bear County, Judge, so he doesn't need probation transfer.
All right, he's going to remain in custody until transferred. And has he done anything on probation? Has he completed the parenting classes?
Yes, he has, Judge.
Yes, ma'am.
All right. All right, is there anything else?
No, Judge, not at this time.
All right, upon release, you need to immediately report to probation. Do you understand?
Yes, ma'am.
And you are not allowed to leave Bear County without the court's permission. Do you understand?
Yes, ma'am.
All right, thank you. All right, Mr. Schumacher, come down. Court is calling 2019 CR 11017W, State of Texas versus Michael Schumacher. Could I have parties announced for the record?
Daniel Escobar for the state.
Sean Hendrickson for the defense.
All right, and are you Mr. Schumacher?
Yes, ma'am.
Am I pronouncing it right? Is it Schumacher or Shoemaker?
Shoemaker.
All right, you're Mr. Shoemaker.
Yes, ma'am.
All right, we're here on a motion to reconsider.
Yes, Judge. Defense filed that motion. We were here about a week ago, Judge, on a motion to revoke his probation. Mr. Shoemaker did plead true to violating his probation by traveling outside of the county. Just for the court's recollection or whatever, he was going on a cruise was the reason he'd gone out of the county. And at the last week when we had that agreement, I hadn't had the time to speak with my client in person about everything outside of the courtroom.
Mhm.
And so that was the reason why we filed the motion to reconsider. I did want to address some things that we were not able to bring up at that last setting. So while he's been on probation, I'd like to actually focus on the last couple of years, because it seems like that over the last 2 years, Mr. Shoemaker has made substantial changes to his life to better himself and to become a better person. So while on probation, he has continued checking in with his probation officer. He's continued having negative UAs. And as kind of outside of probation, he has also worked on his becoming sober. And so I believe that he has a statement that he will make, telling you a little bit about how he has become sober over the last couple of years. In addition to that, he is kind of improved his job situation so he can provide for his family also, Judge. And we do also have a couple of character letters, which I think can describe his, I guess, him outside of the court, outside of the criminal justice system a little bit better than I can do. So I'd like to present those to the court as well, Judge.
All right, the court will review the letters.
And I believe that my client would also.
All right, you want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Michael Paul Shoemaker.
All right.
I'd just like to say, last time I was in front of you a couple of years ago, I had asked you for some, I needed some help with my alcoholism, and you had me do 90 and 90. And I just want to let you know I did complete that, and I have kept going on with that. So I think that has helped my sobriety. I'm not going to be any good if I'm behind bars as far as providing and taking care of all my responsibilities I need to out there.
All right, so here's my question.
Yes.
Why were you not thinking of that before you disobeyed the court's orders?
So I did talk to my probation officer about going on the cruise, and I gave her the time, the dates, and all that, and I never heard back from her. And I don't really have I don't have an excuse. I didn't follow the order.
Probation? On this case, is there notation that he talked to his probation officer about going on a cruise? All right, thank you. All right, you may continue.
I'm just trying to better my life and trying to make better decisions.
But see, that's the problem. You're not making better decisions. And your thought should have been that if I have not heard from probation back on my cruise, you could have came to court, probation officers here, and you could have said, hey, I sent a letter and talked to my other probation officer about going on this cruise, and I haven't had a word back. And you know what they would have done? They would have called that probation officer and they would have said, oh yeah, we're going to put that before the judge and see what she says. When you're on probation, this whole thing where it's better to ask for forgiveness than permission, that doesn't work when you're on probation. And not only did you go on a cruise or attempt to go on a cruise, they arrested you before you could go, but you were going with someone who had a protective order against you. So that's two things you did wrong. One, you were going on a cruise without the court's permission. And two, you were going on a cruise with someone that you were not supposed to be around because they had a protective order against you. And I understand that sometimes women will have a protective order against a guy, and then the next thing you know, they're back together and they're traveling. or they're living together, and then something happens and that person calls the police, and then guess what? You come to court and say, well, I've been living with her. She was fine with it. You're not supposed to. Those are against the rules.
Yes, Your Honor.
Probation?
Yes, Judge, there was notation that Mr. Shoemaker asked for permission. And at that time, the CSO indicated that she wanted him to become more current on his fees and enrolled in his MRT.
See, and you hadn't even enrolled in your MRT, is that correct?
Well, I was getting ready to enroll with MRT, and I had already gone through the list of them, and I had one picked out. And I told my probation officer, and she said to me the last time to hold off on signing up because she wanted to talk to you to see if I still needed the MRT class. So that was the last I had heard from her. She said,
All right,
"Hold
most
off."
definitely you need the MRT because you're not making rational decisions.
Correct.
All right. Any questions?
Nothing to say.
And Judge, I do believe that he is making better decisions than he was before. He has worked on his sobriety, and I don't know that he mentioned this, but after completing those 90 days, he did go through a sober living facility that he successfully completed. And he had been on parole, and he successfully completed parole as well. So we believe that he is making better decisions than he was before. What we're asking for is we are asking for the court to follow the original agreement. However, since this court does have concerns about his ability to make good decisions, we're asking that the court does want him to work on that or enroll in something. There is a course, a cognitive behavior course that is outside of ISF, and we asked the court to order that instead of the ISF.
And what course is this?
I spoke with probation about it. It's 10 classes, 20 hours. I don't have more information than that, Judge.
Probation, what class is this?
It is a course that we I believe go through CATS through. I believe it's through CATS, but it's a cognitive behavior course. It's 20 hours. And it goes for 10 weeks, and it targets the thinking errors and standing cognitive issues.
Okay.
Additional information indicate it develops pro-social attitudes and behaviors.
Oh, okay. All right, thank you. All right. State?
Your Honor, the state would be in agreement. Previously, whenever we were here on this NTR, we did request something that was out of custody. It was 90 days, 50 days. But we do think that this additional requirement will be helpful.
All right, thank you, State. All right, this is what the court will do. The court will reconsider, and the court is going to order cognitive behavioral courses through CATS. And I'll hold ISF in abeyance. Is there anything else?
Nothing from the defense, Judge.
Nothing to say.
All right. All right, we can go off the record. Mr. Shoemaker,
Yes, ma'am.
you need to start making better decisions. The state has agreed to this. You are looking at 10 years in the prison. Do you understand?
Yes, Your Honor.
Everything from here on out that you do, you need to ask yourself if it could potentially result in you going to prison for 10 years. If the answer is yes, you should not do it. If the answer is maybe, you should not do it. Do not do this thing with the court where you are deciding that it's better to ask for forgiveness than permission, because that doesn't work in the criminal law world. You understand?
Yes, Your
All right. Is there anything else you need?
Honor. I don't believe so, Your Honor.
All right. And here's the other thing. That person you were going on the cruise with,
Yes, Your Honor.
there's a protective order against that person. I mean, that person has a protective order against you. You are not allowed, even if they say, oh, oh, we're back together. Everything's going right. You're not allowed to do that. If there's a protective order, which according to what I've received, there is, you need to speak to an attorney to see about getting that lifted if that person wants it lifted. But you are not allowed to be around that person. Do you understand?
Yes, Your Honor.
All right, thank you.
Thank you.
You're welcome.